Welcome everyone to the second Health and Social Care Team webinar that we've had since effectively coronavirus stuck us all in our homes. We did the first one about 2 weeks ago, found it a very, very, very good way to effectively disseminate the knowledge we had, as well as gain information from yourselves. And so that's again what we're trying to do today. The focus today is, as you know, on coronavirus and the 4 Ds: discharge, DNARs, DoLs, and direct payments. I mean, I love the alliteration, but those 4 topics came up out of the questions that we had in the last seminar. So we thought, well, these are obvious areas of interest. So let's have another seminar focusing on those. As you saw on the first slide, so this one, the slides and the recording will be available on the website shortly after the webinar is held. So keep a lookout there. The other thing I want to mention is when you are on our website, there is an events page, and you'll be able to see lists of other webinars that other teams, for example, the housing team, are having in different areas that may interest you. So do have a look there. And then the last kind of housekeeping issue that I wanted to raise is that there is probably at the bottom of your screens a question and answer function. So we've had loads and loads of questions that came in with the registration, but we want to enable that question and answer function in case anyone has any additional questions that they want us to ask. And what we've also discovered is that if once someone's typed in a question, the other delegates read it and like it, the more likes a question gets, the higher it rises up the table, the more popular the question is. And those are the ones that we intend to try and answer during and after at the end of the seminar, just so that we can hit the questions that most people are interested in. Of the questions we received earlier, we've tried to weave them in to our talks and our presentations. But if you feel it's not been answered, please do ask again or contact us later. So moving on. You'll see there we've got a panel for you: Catherine Rowlands, myself, Lee Parkhill, Zoe Whittington, and Tara O'Leary. Set out there what each will be doing. Discharges comes first with Zoe, DNARs with Lee, direct payments with Tara, and DoLs with Catherine, and then questions and answers at the end. What we also thought is we might put in a question or 2 after each individual speaker in order to break it up and provide you with all the information on that topic at the one time. So with that, over to you, Zoe, please.
Thank you, Peggy. So yes, as Peggy says, I'm going to kick us off talking about hospital discharges. This topic has become of particular relevance to social care during the COVID-19 pandemic because of the government's overall strategy to avoid the NHS becoming overwhelmed, which has included, part of that strategy is to basically get people out of hospital as quickly as possible, whether they are COVID patients or in hospital for any other reason. And that's for really obvious reasons, to basically free up the beds and ensure that there is capacity within the NHS to deal with the additional workload from the COVID patients coming in. So where social care really comes into this is the fact that where do they go when they leave hospital? Well, they go into some form of community setting, whether that's back to their own home or whether it's into something like a care home or a rehab bed, they're back out in the community. Now, of course, people would have always had needs for care and support on discharge. They still remain. We still have those people. However, with this emphasis on freeing up beds, people, and what we'll come on to look at in the discharge service requirements, people are being discharged potentially quite a lot earlier than they would have been previously, and without having the same level of assessment that they will have had previously. And therefore, there's an additional increase on the needs for social care input, care and support needs in the community once people are discharged. And also for an increased need for assessment once those people are discharged into the community. So the way in which this is all intended to work is set out in the COVID-19 hospital discharge service requirements, which I've put on the slide there, and I will refer to as either the guidance or the discharge guidance throughout this talk. That, as many of you will be familiar with it, was published on the 19th of March. So we've had it around for some time now. We've had it nearly 7 weeks. And we're sort of getting to the point where we're trying to work, we're getting to understand how it is or isn't working. It is just worth mentioning that that particular form of guidance, as it is at the moment, hasn't been updated following the Adult Social Care Action Plan that was published on the 15th of April. And there is one part of that that is likely to be relevant to social care, which is around the increasing of testing for people being discharged and going into care homes, and the fact that not all care homes will be able to deal with people who need to isolate. That we are expecting will be mirrored or explained into the hospital discharge guidance at some point, but we haven't yet got that. So the guidance itself, it sets out a very tight timetable for discharging. The threshold for discharging from acute or community hospitals is that the person must be discharged as soon as they're clinically safe to do so. The expectation is that they will then move from a ward into a designated discharge area within 1 hour, and then 2 hours after that, they will be discharged from hospital. So that effectively gives that 2-hour period of time in the designated discharge area to do assessments that they won't be full assessments, but assessments that are needed to basically get that person home or get them into some other provision, so a care home, a rehab bed. And therefore it's a really, really tight timetable. In order to assist with this tight timetable, what the government have done is rolled out the discharge to assess model, which did already exist, but is now being used on a national scale. And essentially that does what it says on the tin. It is discharge first, assess later. And when I say assess later, I mean, of course, fully assess later, because there would have been some element of working out where the person needs to go, their basic needs on the day of discharge. Can I have the next slide, please, Peggy? Thank you. The other ways in which this, that's one of the blocks in order to that would normally exist for people being discharged from hospital. There are 3 other main blocks. The first of those is funding, that normally can cause delays. The second is availability of beds, so for community placements, for rehab beds, for care home placements. And the third is patient choice. So just to go over those in a little bit more detail, the first normal block of funding is, of course, probably one of the biggest, and that is what this guidance really it's the biggest change. Under the guidance, the NHS is to fully fund the cost of new or extended out-of-hospital health and social care support packages that are referred to in the guidance. We'll come on in due course to sort of what that means, a little bit about what exactly is funded. But this it applies to people who are being discharged from hospital, but also really crucially, it also applies to people who would otherwise be admitted into it. And it's important to remember that, so it can be actually used to prevent hospital admissions. I've personally seen at least one case of this so far where the funding is being used for someone who was homeless and had mental health problems and some other physical problems and was therefore vulnerable to COVID. And a package has been put in place to try and support him to prevent an admission into hospital, potential admission into hospital. Obviously, the purpose of the increased funding is obvious. It's to try to reduce the pressure on the acute services, but it's also very important to keep in mind that it is, of course, time limited. So we don't know how long we're going to have it for at the moment, but at the moment, this additional funding, it does say very clearly in the guidance, it's time limited. We know it won't last forever, and that patients need to be talked to about the fact that it won't last forever, sort of during the process. The second one, the bed issue, the way in which the government tried to approach that is by extending out the pre-existing North of England commissioning support care home tracker, so that we now have a national community bed tracker system, which covers all care home places, NHS community hospital beds and hospice beds, and all providers were required to sign up to that by the 23rd of March. So they should all now be on there, and that system should be assisting you to be able to place people, to find those beds, as it's constantly updated. And the third, and probably one of the most interesting ones from a legal perspective, is the issue of patient choice. The guidance is really, really clear that if a person needs rehabilitation or a care home placement, then they cannot wait in hospital whilst they wait for their first choice to have a vacancy. So instead, you have to move them to somewhere in the interim, and then at that point you can consider when, if it is appropriate, to move them on to somewhere else for a longer term placement. But it's really just to try and stop that from blocking the beds. When this guidance first came out, it was expected that this may well lead to there being some challenges around patient choice. However, it's looking less likely that's going to happen. We've had one case, the one I've referred to on the slide there, the University College Hospitals versus MB, which was heard on the 9th of April, which hopefully may put paid to there being any further challenges. This is quite an interesting case, particularly if you also do housing as well as social care, but it's concerned a situation where there was a lady who was refusing to leave hospital. She'd been in hospital for a very long time, I think around a year, and she was refusing to leave until she had certain aspects of her care plan resolved in the way she wanted them to be. She disagreed with what was being suggested for her, and she wanted those to be resolved in her favour. As all the COVID outbreak kicked off, the hospital needed the bed, and therefore they served notice to terminate her licence and seeking to evict her. This ended up in court, and she relied on human rights arguments to say that why she shouldn't be evicted. And although it wasn't framed directly as a patient choice argument as such, that inevitably comes into it in terms of you know what she was seeking and what was not being permitted partly because of the circumstances. She had previously been able to stay in hospital before the COVID outbreak. But in the end, what happened was that the judge said that the judge made an order an injunction order to say that she had to leave. Couldn't make a possession order because there's currently a stay on possession proceedings, which is where the housing aspect becomes quite interesting. But ultimately she did have to leave, and it's judgment worth reading, because the reasoning given as to why the human rights arguments failed in this case will apply in any potential other patient choice type challenges. So can I have my next slide, please, Peggy? The guidance is also really clear that the Mental Capacity Act duties still apply during this enhanced period of speedy discharges. So you still have to carry out your mental capacity assessments and your best interest assessments, and DoLs still applies. So those assessments have to be carried out and standard authorizations applied for. What the guidance does say, potentially unhelpfully, is that none of this, particularly the DoLs, should delay discharge. It seems to us that probably is unrealistic, and there's likely to be some level of delay where there are mental capacity issues. Although I suppose the emphasis is simply on just trying to get those assessments done as quickly as possible, and then fuller assessments being done later. But I will come on to the fact that this is there are some concerns around whether or not some of these assessments are being essentially rushed through, which frankly they are, and it's about trying to still have decent quality assessments being carried out despite the time pressures. I've just put on that slide about the fact that it's section 5 of the guidance that really details the specific roles of the local authorities. There is a real emphasis on collaborative working with the NHS and with other the voluntary sector as well, and also of course care providers. There's also the local authorities are expected to take lead contracting responsibility in order to expand capacity with care providers. So it will be you guys who are already, no doubt, dealing with the care providers and trying to ensure that there is sufficient capacity for these additional people coming out and requiring care and support, as well as providing increased capacity in your own social services capacity. And next slide, please, Peggy. So just finally on this slide, I've just set out some of the queries really that have been coming up, primarily anecdotally, about how this is all working so far. Certainly I've heard that there were real concerns about staffing levels, and in particular the fact that there's a massive recruitment drive for social workers who are specialists in hospital discharges and to go into those roles. Obviously there already were social workers doing these jobs, but there's an increased demand for them. As I've already mentioned, the potential rushing of mental capacity assessments, the issues around there being still being insufficient care home capacity, and also refusing to take people who may be isolating, and also clarity over the funding. And that takes me to the end of that presentation.
Thanks for that, Zoe. If you could briefly, you've got a minute or two at most, answer one question that's come up, which is, does this funding, the COVID NHS funding, cover the total cost of the package that they have once they're discharged, or only the increase in cost of an existing care package?
Thanks, Peggy. The guidance is a little unclear. Now, my reading of the guidance is that it applies to new or extended packages, which is what it says, and it refers at several points throughout the guidance to it being to new or extended, or to them being ones that come out of the discharge. My reading of that is that it is, if there is something additional, it specifically says in the guidance that if you've already got a care package pre the 19th of March when this guidance came out, then it will be whatever funding was already in place for that will continue to apply. So whether that was self-funding, whether that was a means-tested local authority care package. However, and the caveat here is that there is one part of the guidance which goes on to suggest that the restarting of care packages where someone was had a care package previously, so someone was in a care home and had that provision already there, that will be covered. And it is a little unclear quite what is meant by restarting, and whether or not that would be the case, even if there was no change to that original care package, or whether it requires there to be something additional. It seems to me that it is likely that in most cases there may well be something additional in any event, and therefore that additional aspect would be what would be covered. But as I said, there's this slight grey area. My view is that it is more likely than not that it is only if there is something additional and not to the original care package.
All right, thank you.
Peggy. Sorry.
Yep.
Can I ask Zoe a quick question? I'll be quick in my presentation, so I will make up the time. So can I ask, I was interested in the point about choice. It seems to me there might be a tension with local authorities doing the commissioning if the choice of accommodation regulations are still in force. Does the guidance address that, do you know, or should I not ask this question?
The guidance doesn't address it at all. It's and I think it's the glaringly obvious area which it needed to address. There isn't any suggestion that that when it gets updated that is going to be looked at, but I guess until
a local authority exercises the easements to suspend the choice of accommodation provision, then if the local authority is commissioning, it should be giving choice, really.
Absolutely.
It seems the guidance has missed that. Okay, well, as long as that was my understanding, I thought I'd check with you.
Yeah.
Thanks, Lee, for that. I think you're actually on next.
Brilliant, thank you very much. So I've got the pleasure of talking about the very jolly subject of do not attempt to resuscitate. and making decisions, clinical decisions, to not attempt to undertake resuscitation of patients. So before briefly looking at the legal regime and what the relevant factors to consider are, I think it's helpful to remind ourselves what CPR is about, or familiarise ourselves with it if we haven't had to think about it before. And the most important document to look at when talking about CPR and decisions about DNA CPR is this guidance issued jointly by the British Medical Association, the Resuscitation Council of the UK, and the Royal College of Nursing. And that really gives you all of the detailed overview of what's to be considered in DNA decisions. But it gives you a description of what CPR is, and it describes it as an invasive and traumatic medical intervention. It usually involves chest compressions, attempted defibrillation, injection of drugs, and ventilation of the lungs. So clearly it's a very significant undertaking, and it's as described, traumatic. So what about the effectiveness of it? Thanks, Peggy. Well, I'm afraid the picture doesn't get much better when we look at effectiveness, because the guidance tells us the proportion of people who undergo a cardiac arrest, have CPR, and then survive and get discharged is in the region of most hospitals of 15 to 20%. So it's not hugely effective at saving lives. So again, the picture is not terribly positive. What about the risks of doing it? And the next slide, Peggy. Thanks very much. Well, I'm afraid the picture continues to get bleak, because the guidance tells us that there's risks associated with undertaking CPR, which include brain damage that can lead to permanent disability. So given that this is a very traumatic and invasive process, it's not got a particularly high success rate, and there are risks involved with it, I think it's clear why clinicians stop and think about whether they're even going to embark upon it. And this isn't something that's mentioned in the guidance, but I think it's perhaps relevant to recognise that it must be a traumatic and draining experience for the clinicians to try and undertake it. So that's the context of what we're talking about. What's the legal framework? Well, the decisions not to attempt CPR, because this is life-saving treatment or potentially life-saving treatment, a decision not to attempt CPR engages a patient's Article 8 rights. So that's the first sort of legal imperative to bear in mind. But the second one to bear in mind is that patients can't force doctors to provide treatment, any particular treatment, and for any reason. Doctors can't be forced to provide treatment that they don't want to provide. So there's potentially a tension here, you might have thought. So the way it's resolved is that the Article 8 right that patients have in respect of DNAR decisions is not a positive right to require that they be given CPR, but they have procedural protections in respect of the decision not to give them CPR. So it's a procedural right under Article 8. So before we look at the decision-making process, just thinking about refusals of DNAR, refusals of CPR if that's to be offered by clinicians. Well, clearly a patient who's got capacity can refuse to consent to it. If a patient had capacity but has lost capacity, now lost capacity, then the clinicians need to be aware of any advanced decisions to refuse life-saving treatment. And the Mental Capacity Act, section 24, provides for advanced decisions. And if an advanced decision is to operate to refuse life-sustaining treatment, the advanced decision has to be in writing, it has to be signed by the patient, it has to expressly talk about life-sustaining treatment, and it needs to be witnessed. In the absence of that, there is no valid withdrawal of consent for life-sustaining treatment. So that's how the patient can refuse CPR. Just a couple of other points to flag up. Deputies, whether they're a deputy even if they're a deputy for health and welfare, the court cannot ever give a deputy the power to refuse life-sustaining treatment. That's just not possible. An attorney under a lasting power of attorney for health and welfare can have the authority to make a decision to refuse CPR, but only, of course, if the patient lacks capacity at the time, and if the LPA has expressly conferred the authority on the attorney to make a decision to refuse life-sustaining treatment. So now turning back to how you make the decision or how the decision is made, to emphasise, it's a clinical decision about what clinicians are going to offer. That's what we must remember. This isn't actually a best interest decision being made on behalf of the patient. It's a clinical decision about what services to offer. So ultimately, the responsibility rests with the most senior clinician responsible for a patient's care. Usually in hospital, that will be a consultant, but in the community, it might be the GP who is overseeing the patient's care. So what are the procedural rights that the patients have here? Well, generally what they amount to is a right to be consulted by the clinicians when they're thinking about making their decision not to attempt resuscitation, and also to be informed about the decision. And those rights were established in the Tracy case in the Court of Appeal. Now, there are certain exceptions to those rights. Clinicians can decide that they're not going to consult you about a decision on DNR or not tell you about it, but those are very much exceptions. The general rule is that there must be consultation and communication, and the doctors can only refrain from doing that if they can show that, or if they've got a good basis for thinking that there would be psychological or physical harm by approaching the subject with the patient. But that's quite a high test. The courts emphasise that there's always going to be some distress discussing these topics with the patient. You need to have more than, you have to be in the territory of harm arising from the discussion. And if there isn't consultation without good reason, then you're in the territory of breach of Article 8, and you could potentially bring a claim in respect of that. The next slide, Peggy, thank you very much. What about if the patient lacks capacity? Well, if the patient lacks capacity, the consultation requirement that would normally apply with the patient is supplemented by Section 4.7 of the Mental Capacity Act. And this is established in the Winspear case. And Section 4.7 of the Mental Capacity Act says that if you're making a decision on behalf of somebody who lacks capacity, you have to consult, if it's practicable to do so, with people named by the patient as to be consulted, or someone who's engaged in their welfare, or an attorney or a deputy. So if the patient's got capacity, you consult with them. If they've not got capacity, you consult, if it's practicable, with people who are involved in their care. And the Winspear case, the court held that there hadn't been consultation when there should have been. The decision was made in the early hours of the morning. And it was possible to ring the patient's mother, but they thought they'd not disturb her and speak to her the following day. And the court said, well, it was practicable to consult her, even if it might have been inconvenient. Therefore, they hadn't consulted in compliance with Section 4. Therefore, it was a breach of Article 8. And there were no damages awarded in that case, just the declaration. Thanks, Peggy. So what about resolving disputes about this? Well, if the family or patient are not happy with the decision to not attempt CPR, then they can ask for a second opinion, and generally they will be provided with a second opinion. Again, this is all spelled out in the guidance. But then there's no right to a second opinion, and the court emphasised that in Tracy. There's no right in Article 8 terms to have a second opinion, and you might not be offered one if you've got a multidisciplinary team and all of the clinicians in that team all agree. But generally, you'll get a second opinion from another unrelated, experienced doctor. Ultimately, I suppose if there is a dispute, you could ask the court to explore the issue. But we've got to remember, I've given you a quote there, Lord Justice Ward in ADS, that the court can't compel clinicians to provide treatment that they don't want to provide either. So unless you've got a clinician who is saying that they would deliver CPR, proceedings are unlikely to result in a radical change to the outcome. So if you've gone through the second opinion process and got no different decision, proceedings are unlikely to add very much to it. But of course, the court's always there to consider these issues and explore the matter. So that's my run through of the framework for DNA CPR decisions.
Lee, one question that came up, or something we see in all the papers, is this blanket policy for DNRs or DNR CPRs. What's your view there?
Well, that's a huge problem. Absolutely not permissible. There has to be an individual clinical assessment of all cases. Of course, there might be factors which are relevant to all patients, which potentially point in a particular direction, but there has to be an individual decision. There can't be any discrimination in these decision making. So blanket policies are absolute no, and if there's any sign of them, then they need to be challenged. It has to be an individual decision, a clinical decision in every single case, which the individual clinicians are responsible and accountable for, and going to have to explain at some point.
Okay, no, thank you for that. And then just one small point that I may not have picked up upon that has been echoed in a question. I think you said when they've got capacity, the doctors talk to them, consult with them, and when they lack capacity, with the relevant persons. If they have capacity, does the doctors need to consult with family members as well?
Well, that's a little unclear, and it potentially depends on factors to consider in that scenario, obviously confidentiality of the patient. And I think it perhaps depends on whether the doctors are minded to conclude that consultation with the patient themselves would cause harm. So if the doctors are thinking that the patient's in such a difficult state and such an unstable state that they don't want to discuss it with them for fear of causing acute anxiety, then that may be a territory where it's appropriate to consult with family members to gather wishes and feelings that might inform the clinical decision. So generally, if the patient's got capacity, it's just a discussion with them. But I can see in certain circumstances where the patient technically has capacity, but maybe the doctors don't want to broach the subject with them, a consultation with the family members would be informative, but there's no obligation to do so. It all depends on the presenting circumstances.
All right, excellent. No, that's really helpful. Thank you, Lee.
Great. Thanks.
Tara, I think you are up next with direct payments. Sorry, I'll get your first slide. There it is. Over to you.
Thanks, Peggy. You all got a sneak preview there of a direct payment slide. So I hope I'm not treading on things you've already read. So one of the points that arose out of the last community care seminar that we did in Chambers, and also in some of the questions that came in advance of today's seminar, was in respect of direct payments, how local authorities are going to deal with requests for new direct payments or different use of direct payments during the coronavirus lockdown, when people's care arrangements might be changing, and in particular, what happens when someone wants to pay family members to provide care. So I'm going to try and focus on that more or less for the next 10 minutes. Before I get into what's new, I think it's worth very briefly reminding you of some of the usual and normal principles that apply in respect to direct payments. And I do that because these haven't been affected or amended by the Coronavirus Act 2020. They're not mentioned in any of the easements or the guidance on easements. And so these principles should be informing any decisions that you make about direct payments over the coming months. So firstly, first point really is that direct payments, the duty on local authorities to provide them is generally considered to be a mandatory duty, as long as the relevant statutory conditions are made out and none of the statutory exemptions apply. A person receiving care is entitled to receive direct payments and to have some freedom of choice and employment in how that's provided. I've just lost my slides, but I'm sure they will return to us in a moment. What's important, there we go, thanks Peggy. What's important is, however, is that one of the statutory conditions is that local authorities need to be satisfied that direct payments are the appropriate way to meet the needs in question. Now, that leaves a very large measure of discretion in local authority hands. The statutory guidance, I've referred there to paragraph 1219. What that says is that that discretion is not to be used to arbitrarily decline requests for direct payments, and that there is a general expectation that direct payments will be appropriate. So there's a presumption in favour of making them, and you're going to have to come up with cogent reasons as to why they're inappropriate when you find the right case for that. The second point about direct payments is that they can only be used to pay for assessed eligible needs. And so I'm sure you'll all have had cases where family members, for example, spend a lot of time voluntarily taking P out to the community, engaging in social activities, doing things that they think are very important for them, but that haven't actually been assessed as an eligible need under the Care Act. At the moment, you might be faced with requests such as arguments that somebody needs to provide a certain type of therapy online and they're paying extra for that during lockdown. If it's not eligible, unfortunately, you shouldn't be funding it through direct payments. And the other point is that requests for direct payments can be made at any time. And what that means is that it doesn't have to wait until somebody is having an assessment carried out or is coming up to a review. They can request the change to direct payments whenever they want. And the guidance, which is still in force, says that you should process those requests as swiftly as possible. you should not hold up a decision on direct payments pending review. Now, in the normal course of events, the guidance recommends that you expedite the review to facilitate the decision on direct payments. Whether or not you are able to do that at the moment will probably depend on whether or not you're relying upon the easements, and if you are or are not, how quickly you might be able to make some sort of summary decision. But in any event, that's an important point to bear in mind, as this cannot be kicked off into the long grass. A final quick reminder, there's no power to force direct payments on somebody unless they request them or they're willing to give consent to them. Just because their care arrangements might be changing during lockdown doesn't mean it's open to you to unilaterally decide that you used to pay for things directly and now you're going to send direct payments instead. So next slide, please. Thank you. Family members. The short answer is that direct payments can be paid in many circumstances to close relatives of P in order to provide them with either meeting their care and support needs, or alternatively, direct payments can also be used to cover administrative support, by which family members might help with accounting and keeping records of expenditure and so on. Now, if you open up Regulation 3 of the direct payments regulations, it's sort of phrased a little bit backwards in terms of it says direct payments must be made, but cannot be made to certain persons unless certain conditions are made out. And I think a much better way of thinking about payments to family is to bear in mind the principle that there is no legal restriction on payment of direct payments to family unless each of 3 conditions are satisfied. So the first restriction is that it must be a relative who's named within Regulation 3 of those regulations. That sets out an exhaustive list of the family members who may not in some circumstances be allowed to receive direct payments. There's a spouse or partner, fairly straightforward. At paragraph 2, you'll see I've given you a sort of a synthesized list of a number of close relatives. And as I say, that is exhaustive. In addition to children, parents, grandparents, it includes siblings and aunts and uncles, in-laws and step-children, possibly step-parents as well, or the spouse or partner of any of those individuals. Interestingly, it does not include cousins. So there's no legal restriction at all on paying direct payments to cousins or other members of an expanded or wider family. And then the second condition is that those relatives named in the regulations must also live in the same household as P. So again, someone who lives elsewhere can receive direct payments without issue. The third condition is that the local authority must judge it is necessary for the payments to be made to them. And again, that's where an element of evaluative assessment comes in on your part. Now, I have sought but have been unable to find any case law from the courts which casts guidance on either the meaning of living in the same household or on the necessity test. Living, I think, is an interesting one because at the moment, I think there's a question mark as to whether that should be read as meaning ordinarily resident in the sense that P principally spends most of their time living with that person, or whether it should be read more narrowly so that, for example, if they're living together for the time being, they would be included within that definition, such that if P has left their own home but has moved in with some family for the duration of lockdown, that would meet that definition. The safest thing for local authorities to do is most likely, if you have a temporary living situation, satisfy yourselves that it is necessary for the payments to be made to that family member. Because if I'm wrong about that and it's an ordinary resident situation, then there would be no restriction on making payments to anyone who doesn't ordinarily live with P, but might stay with them at the moment. The local government ombudsman has considered a number of cases which do touch on the necessity test, and the statutory guidance refers to it as well. And I think what's important to take away from that, whilst it's not guidance from the court, is essentially that it's not a high threshold, and it shouldn't be held up as something where there needs to be any exceptional reason to make payments to family members. The LGO has in a number of cases found fault or administration in circumstances where local authorities refused to make direct payments on the basis there was no exceptional reason to give them to family members. So it would avoid that approach. The guidance suggests that no unreasonable restriction should be imposed on them. What is reasonable, again, is for the local authority to decide, but may well be different in the context of coronavirus to what it would normally be. Next slide, please. And so when we come to the current situation, as I've said earlier, the Coronavirus Act and the easements don't actually comment at all on direct payments. And so all the principles I've applied so far, discussed so far, still apply. What did emerge instead was COVID-19 guidance for people receiving direct payments. It wasn't published until the 21st of April, and there was a great degree of unhappiness amongst disability advocates as to the delay in that, because it came about a month after most of the other guidance, at a time when people who are receiving direct payments and employing carers directly were particularly concerned about how they were going to ensure their care would continue and procure PPE and so on. What may not be readily apparent, because this is in its title says that it's for people who receive direct payments, is in fact it does also provide guidance for local authorities. And so anyone who has any concerns or troubles about this issue at the moment, I highly recommend you read through it. It's accompanied by quite a detailed question and answer document, which has I'm not sure how helpful all the answers are, but they do touch on many of the very relevant questions which are being asked at the moment. So there, in the guidance, there is firstly a particular section which deals with steps to be taken by local authorities in relation to DPs. Now that is generally at a rather macro level, so it encourages, amongst other things, steps such as ensuring you have an up-to-date list of individuals receiving direct payments, mapping the care and support that's provided by way of direct payments, and contacting everyone who receives direct payments to provide information and I suppose provide a line of contact in the event they need assistance. I've seen from some of the questions that were sent in advance of today that there is some concern about local authorities being somewhat uncertain as to how much information they are required to provide. That's as much as the guidance says, is simply provide information. So I think as long as you are responsive to questions that come in, and in particular you are responsive to anyone who might find themselves in a somewhat emergency situation where their carer or personal assistant cannot come anymore because, for example, they're self-isolating or they've fallen ill, that's the first and most important thing to focus on doing. But beyond that, there's lots of useful guidance, including on very practical steps as to how carers should help to clean, dispose of waste, use PPE in relation to the persons who are receiving direct payments. And you'll see that there is a very explicit approval of using family members to step in and replace cover, which is endangered during the pandemic. LAs are encouraged to be flexible, and in particular, they are encouraged to continue responding to requests as quickly as possible. So first of all, there is absolutely no presumption in the guidance that it is inappropriate to rely on the support or assistance of family members where it's appropriate and necessary to do so. Quite the opposite, it's repeatedly given, family members' assistance is repeatedly given in the guidance as something that may need to happen in order to ensure continuity of care. The other 2 points I would very much take away from the guidance are be responsive as much as is reasonably prompt in the particular circumstances you may be dealing with in your district. And secondly, to be both flexible but also creative. Various answers in the Q&A section of the guidance make reference to sort of contingency plans and temporary arrangements. And they very often give the example of saying something might be appropriate for 4 weeks. So come up with a temporary plan with someone who contacts you for assistance. And as I'll discuss in a moment, that may well be, well, family can assist you for a couple of weeks without needing direct payments to do it. Alternatively, it may be, you know, a family member is actually going to have to resign from work in order to care for you, and therefore we would agree direct payments are necessary for a 4-week period after which to be reviewed. There are likely to be 2 different types of requests for direct payments coming in the coming weeks. One is that a person who's already getting direct payments asks permission to use those payments differently. The other is where a person who has previously had their care paid for directly now needs to make different arrangements and wants to receive a direct payment for the first time in order to pay for that. If you cannot carry out a new assessment of their needs or of their of how that should be funded, as I say, if you're not relying upon easements, then you should try and respond to that as quickly as you can. And it may be that you don't provide a complete Section 9 compliant assessment of their care needs, but you might be willing to fund a certain number of hours of care in order to allow family members to care for them informally. So Things to bear in mind, the easements generally are not to be treated as a license to abandon your Care Act duties without adequate and necessary reasons to do so. And so for the top bullet point and the bottom bullet point there, I've asked, do you have cogent reasons either for relying on the easements and not complying with the full extent of your duties, or secondly, from departing from the normal statutory guidance, the COVID-19 direct payments guidance that I've just referred to, or indeed any local policy that you might have on direct payments, which some local authorities do. If you think it is not necessary to make these payments, or you think it's not appropriate to do so, you need to be able to provide reasons and evidence for that. And I would say the same if you are going to say, well, someone doesn't need direct payments because we don't anticipate a breach of their human rights. Why is that? And the reason I've put that second bullet point there is because on a number of occasions, the LGO has again found fault in circumstances where local authorities decided there's no good reason to pay direct payments to family members or in other circumstances, but they didn't provide any thought or reason or explanation as to how the care would be provided in another way. So if you are going to refuse to pay direct payments, do be able to provide reasons for that, and do address that in some way, whether it's in writing or in a summary assessment, in order to be able to persuade anyone who complains of that why it is that you were satisfied. There won't be any difficulty. The questions that came in advance of today sort of asked, well, if family members are willing to help in any event, why do they need direct payments? And surely we can be content that there will be no breach of P's human rights if their family are going to take care of them. That's a highly fact-specific question. So what I would say is that you might well be satisfied there would be no breach of anyone's human rights if family took care voluntarily for 2 or 3 weeks without direct payment. But if the family very clearly say, I can only take 2 weeks off work and after that I'll have to go back, or I'll have to resign, or I'm going to lose earnings to a point that I can't sustain anymore, what might have been acceptable on a temporary and exceptional basis for a short period of time would become different if it became extended. So no hard answers to this, but hopefully some points for you all to think about. I'm aware I've more than run over my time, but thank you.
No, you certainly have, Tara, but if you could just give us a one-word answer to this question that everyone is asking is, does the furlough scheme apply to carers who are paid by direct payments? Yes. And the question and answer session of the guidance deals with it in quite some detail. If the carer becomes sick, they might become eligible for the statutory sick pay scheme. If they cannot attend to the person because the person themselves, rather than the carer, has become sick, then or needs to self-isolate, then they can potentially apply to furlough. But the guidance says that hopefully it won't be necessary very often. Carers are essential workers, and if need be, redeploy them so that they can be used to look after somebody else in the short term, if that's a sensible thing to do. Cool, excellent. Thank you so much for that, Tara. And now we've got Catherine as our last speaker talking about deprivation of liberty. Catherine?
Well, deprivation of liberty, there have been a huge amount of questions already come in on this, so forgive me if I don't get to the one that you wanted to know about. And of course, deprivation of liberty is something that we are all now getting rather more used to and we understand a little bit more about. Got some guidance on this as well, but a lot of what Tara was just saying about her section applies in this section as well. Situation as normal so far as possible, but be flexible, creative, reactive. And the key word that the guidance gives us is be proportionate. Be proportionate rather than whatever it was you were doing before. Heavens, I'm sure you weren't being anything other than proportionate before. But Article 5 still applies. There is no derogation from that at the moment. So the guidance is non-statutory guidance, but there's no reason really not to follow it because, in my view, it's slightly bland, generic guidance. It applies across, of course, the whole range of cases, whereas the answer to any question in any individual case is going to be very fact-specific, and it's going to be something for you to appreciate on the evidence before you at any particular time, understanding, of course, that it can change really quickly. So the key points, as I say, are to be flexible, to be proportionate, but also to keep good records, because as long as you're writing down what you're doing and as long as you are doing the best you can in the circumstances, the guidance suggests that you can give yourself a bit of a break. Don't be too hard on yourselves, be kind. The guidance says, it's the department's view that as long as providers can demonstrate that they're providing good quality care and or treatment for individuals, and they're following the principles of the MCA and the code of practice, then they have done everything that can be reasonably expected in the circumstances to protect the person's human rights. So, sorry, can we just go back to the previous slide? There are two key issues. Where there are changes to the usual arrangements, what effect does that have in relation to deprivation of liberty safeguards, and what are the practical arrangements for carrying out assessments? And the other key issue is the guidance is very keen to ensure that we're not taking blanket decisions. Just as Lee was talking about in DNAR cases, you can't have a one-size-fits-all. So it still is a question of tailoring things to the person in question. Changes of arrangements may mean that you have got changes to provide treatment to someone to prevent deterioration when they may have or be suspected to have COVID, when you're moving them to somewhere else, either for their own good or for other people's good, and particularly in relation to protecting them from being infected with COVID, including support for them to self-isolate or be isolated for their own protection. And it's a question of graduation. It's a question of the changes that are made to any particular person's care. And it might indeed amount to a significant change to arrangements that do need a new best interest decision. And the guidance emphasises your best interest decision can't be based on the best interests of the community globally. That's a public health issue, and there are public health efforts that can be done to deal with that. But what is in P's best interests is still the key. It may, in my view, be in P's best interests to be prevented from going out if he is not able to understand the need for social distancing, staying 2 meters away from people, obeying the new rules and regulations that we're all getting used to. Because in some communities, there are reports of people being subject to aggression if they're not obeying the rules. And so it might be in P's best interest, if he's the kind of person who wants to go and throw his arms around people in the street and who might get aggression as a result of that, might be in P's best interest to remain. It's kind of like the Skripal case, who, if you recall, the issue is whether he should be giving his blood to be tested. That was deemed to be in the best interest of the community, but in his best interest as well, because he was the kind of person who wanted what was best for all of us. Life-saving treatment will not amount to a deprivation of liberty, according to the guidance, where it would be the same even if the person were capacitous. So that's the Ferreira case. Do you remember this was the one where the lady with Down syndrome, end of life, ended up being sedated and subject to treatment, which really did deprive her of her liberty in a very real sense. But she was being given the actual same treatment that she would have been given regardless of her mental capacity for her physical ailments. And this was not seen as being deprivation of liberty in those circumstances. The Ferreira case doesn't go into what is actually meant by life-saving treatment. And in my view, there's no reason why life-saving treatment shouldn't be given a very broad interpretation. But clearly, Lee spoke to you earlier about the kind of CPR end-of-life treatments. And all of those can amount to a deprivation of the liberty. People are simply being pinned down and treated. And that kind of thing would be given to you whether or not you are capacitous. And so that would not be deemed to be deprivation of liberty. In terms of practical arrangements for assessments, Mr. Justice Hayden is very keen, as we will see in this case of BP and Surrey, for people to be creative and flexible about carrying out assessments, and in particular doing capacity assessments by video. There are obvious difficulties in that. People might not have the tech, people might not be able to use the tech, people might not be able to put themselves across as fully as they would do face to face, simply because they don't react as well to somebody on a screen. All these things can be taken into consideration by a sensitive assessor. It's also difficult to know if someone's being prompted from someone off screen. For example, as a witness might be in court as well, that's an issue there. So you need to make sure that your arrangements as to how you set these things up are clear. You can rely on information from previous assessments to see how P has developed or changed, and it has to be assessed on a case-by-case basis. Be flexible, record what you're doing and why you're doing it, and record why you're not doing something else as well. So that is the government guidance. It dates back to 9th of April, which seems like 1,000 years ago now, but it hasn't changed in that time. There is the opportunity for you to give feedback to it if you think that's anything that needs changing, but because it is so generic, I don't think there's anything that needs updating. We get perhaps more practical guidance from the cases that are hitting the courts, and the key one is BP and Surrey. And this is a judgment of Mr. Justice Hayden from the 25th of March, which you recall was just about the time of lockdown. And the gentleman in question had not just dementia, but he also had hearing loss. He was 83. He was able to communicate through a communication board, and he was at real risk of dying if he contracted coronavirus. And his litigation friends, his daughter, wanted him to be discharged from the care home where he was to her family home, where she would look after him solo. And Mr. Justice Hayden refused that application. One of the things he was keen to emphasise in this was that the capacity assessment, which had been put on hold, should go ahead by video, and the doctor was prepared to do that. And Mr. Justice Hayden went into a great discussion as to the effect of Article 5 in emergency situations. And at the end of it, the parties worked together to develop a creative plan for contact. And they were going to go to the care home and look at him through the window. The communication board was going to be used, but he wasn't able to use tech because of his issues. Mr. Justice Hayden said in that case, there is a need for heightened vigilance, he said, to ensure that BP's fundamental rights are not eclipsed by the exigencies of the coronavirus pandemic. He said, it strikes me as redundant of any contrary argument that we're facing a public emergency which is threatening the life of the nation. That's not a sentence that I or any other judge of my generation would ever have anticipated writing. The striking enormity of it has caused me to reflect at considerable length before committing it to print. But he goes on to say that this is a situation where we're in an unprecedented pandemic crisis, and fundamental rights and freedoms require to be protected as vigilantly in times of crisis as in less challenging circumstances. The follow-up, though, is disappointing because the capacity assessment didn't happen. When the doctor tried to do it by video or by visiting the home with protective equipment, it was just impossible for him, in his view, in the doctor's view, to carry out the final capacity assessment that needed to be done of BP. That didn't change Mr. Justice Hayden's view that they can be done in the right circumstances. Capacity assessments can be done remotely, creatively, and by working around the particular circumstances of each case. And what had happened was that as a result of the lack of contact, BP had actually gone into a situation of being depressed, and the parties agreed that he will now actually return home or go to his daughter's home when carers can actually be put in place. And so, you know, with the best will in the world, what was tried to be done couldn't be done. And that may be indicative of the way we go forward. So if we can have the next slide, thank you. The Court of Protection is working its hardest to keep things going as best possible. I've given you the link there to some guidance given by the Court of Protection. They're giving out lots of guidance as to things like judicial visits and the way to deal with hearings. And most of the hearings are being dealt with by telephone. I've also given you a link there to 2 Court of Appeal cases, giving you guidance as to the participation of P in the hearing. And these come from children cases, but they also relate to the kind of hearings that we're having in the Court of Protection. And you should be very acute to look at the guidance and decide whether or not this is a case that can properly be dealt with remotely, whether it can go ahead with P participating, or whether this is something that should be put off. Don't forget, it is possible to have hybrid hearings where there are some bits done live, some bits done remote. It's the difficulty of hearing witnesses that is the really key problem. I am finding that it's easy to do submissions remotely, other things are less easy. What we're also finding is that there's a blanket refusal from the NHS to do Section 49 reports. They're just writing to the court and saying nothing for the next 3 months. You can see where they're coming from. You can also see the problem that creates. So again, be creative as to how you can get the evidence that you need in your particular case. We're also finding anecdotally special visitors may be difficult to get hold of. And is it possible perhaps that judges are a little bit more, let's say, fair about what they're deciding in these cases, because they have got to simply get on with things, and we've all got to get on with things. And I go back to what I said earlier, let's all be kind, let's all be a little bit creative. Now, I just wanted to mention before I finish, on the next slide, this is quite an important point that we are raising, which is the question of whether the court can approve standard authorisations beyond 12 months. It's always been sort of assumed that it doesn't have the power to extend a standard authorisation more than 12 months. Lee's view, and please do come back to Lee in particular, because he's tried this twice in court, or possibly more than twice, is it, Lee? And it's worked, that it is possible, because there's nothing in Section 21A that actually sets out any limit as to the court's powers. The court has the power to determine the period of any standard authorisation. It's not capped. So we think the court can do this. If you're in the situation where you've got problems getting all the stuff together that you're going to need to bring to the court, or bring to your new standard authorisation, it is possible. Another way around that we've thought about is to put into an order a recital that, were it not for the fact that it can't go beyond 12 months, the court would have authorised the extension. That means that it's a technical breach only, and so there's no entitlement to anything more than nominal damages. And belt and braces, why not stick both in your order? So we do think that you can get the court to continue a standard authorisation beyond the 12-month period that normally people think. However, Mr. Justice Hayden doesn't think that, so you may be on an uphill struggle. However, it's worth a try. Do send us instructions in the right case, and Lee will be delighted to argue that for you. Right, I know we're running out of time. I know there are plenty more questions, and do feel free to email us all with any other questions arising out of what we've said today. And thank you for your attention over the past hour and 5 minutes. Back to you, Peggy.
Thank you, Catherine. Yes, echo what Catherine says. First, we back Lee, so definitely send an instruction.
Thank you.
And second, yes, we've run out of time, but please do contact us by email if you've got any other queries or questions. And we'll hope to use those queries to set up our next seminar or webinar. So please do watch the space. Thank you very much, and thank you, everyone.